In this 2 week period that we're now entering for this course, at least, we're addressing the topics of procedures in civil lawsuits and procedures in criminal lawsuits. And this is a screenshot video which is to accompany the first posting in what I have called the typical events in a civil lawsuit. And the way I intend to go about this is I'll put up a posting about some of the typical events. And after each posting, I will then do the screenshot video, and then we'll move into the next area of typical events. So this is how we're approaching the civil procedure. We'll do the same in a slightly abbreviated way because it's simply less complex when we talk about criminal procedure. So the first typical event that we want to talk about in a civil lawsuit is something that I've called pre-suit considerations. And I'm taking this from the point of view of an attorney, but certainly that's the door that we open to get a understanding of what's going on in civil lawsuits. And what we could sort of envision is that a lawyer has been contacted by an individual or a business or perhaps a governmental unit, believing they have a legal problem or perhaps have a legal claim. And the question we're simply asking here, even before the lawsuit is going to commence, if there is one, is what is the lawyer doing in this period of time? And as I point out, the lawyer is first going to need to make an assessment whether there's a valid legal claim that could be advanced in a lawsuit on behalf of the individual or business. And I don't think we have the time to get into this area, but let me just say that a lawyer has an ethical obligation to not pursue a claim on behalf of someone unless the lawyer, with a good faith and reasonable belief about the law, reaches the conclusion that there is at least some likelihood that the lawsuit will advance the interest of his or her client. And when I talk about this, I like to imagine that if we have our hypothetical law firm, we've been contacted by parents whose a child was recently attacked by a dog in the neighbor's yard, and they want to consult about a possible claim. So certainly the lawyer is going to meet with the parents to get as complete of a factual understanding as they can. And the lawyer may not have handled a dog bite case, uh, or in my instance, in my role as a lawyer, I haven't done one, represented a client in conjunction with one in quite some time. So what I would then also have to do is not only be prepared to talk with the parents about what happened, and then given the age of the child too, I would hope at some point soon, but also I want to make certain I understand what the legal standards are for a dog bite. Another pre-suit consideration is one that a lawyer by necessity has to make, and that is, where are the attorney fees coming from? You'll see here in posting one, I'm looking at this language, I spoke about legal fees. That was in conjunction with another course, and we won't be talking about legal fees, other than to say in this dog bite case, for example, if the lawyer felt the claim had merit, he would ask the parents to sign a retainer agreement. In the terms of that retainer agreement would state, among other things, that the lawyer would receive no fee until and unless there was some type of recovery, and then the typical percentage is a third. We call this a contingent fee arrangement. If it's a commercial contract case where there was a fight at the widget factory between business A and business B, my guess is the lawyer is going to be asking to be paid on an hourly basis. But certainly the lawyer at this point has to come to grips with the resource question. Then another area, this isn't a pre-suit consideration per se, but I think it's useful to give a little bit of thought about, is how long does a civil lawsuit last? In New York State, the legislature has created two different categories of civil lawsuits, actions and special proceedings. Our bread and butter types of cases, personal injury cases, divorce cases, breach of contract cases, would be called actions. Special proceedings include everything that's going on in family court. And a particular type of special proceeding, which has nothing to do with family court, is something in New York State known as an Article 78 proceeding. And in that case, an individual or a business is bringing a lawsuit against a government unit for some type of non-monetary relief. Let's assume a developer has bought an existing drugstore in, I'm just going to pick on the town of Elma. I think it's a very nice place. And what the developer wants to do is convert this sort of neighborhood type of drugstore to a bigger box drugstore like Walgreens or CVS or Rite Aid, one of those kinds of places. Before that work can be done, before the property can be converted to this, which would be in a way a new use because it would be an enlarged use, the developer would have to obtain a special permit from the town. And if the town board or the town board planning committee, it's going to depend upon the suburb, doesn't issue the special permit, the developer, believing perhaps that the town board is wrong in denying the application, will bring a lawsuit in New York State, and it's called an Article 78. The reason it's called Article 78 is we're about to see the main law governing civil procedure in New York State is called the Civil Practice Law and Rules. And in this type of case, the number of the article that sets forth the procedures is Article 78. If you wanted an example of another type of special proceeding, we could think of a landlord and tenant eviction proceeding. As I point out, actions are typically fact intense, means there's any number of possible contested facts in the lawsuit. Special proceedings, on the other hand, have a limited range of issues, even if they're extremely important. The special proceeding, typically it's, did the tenant pay rent? Did the town board have a sufficient legal reason with sufficient facts upon which it based its denial of the application for a special permit? I point out that in New York State, the legislature has created different sets of procedures for actions and proceedings. In conjunction with those differences between those categories of lawsuits, I would tell you that an action is more likely to last a lot longer than a special proceeding, again, given the need to get all of the contested facts sorted out, and there's different events that are going to follow that we can talk more about that. Lastly, though, for this screenshot video, and again, you'll see it says on page 4, the textual outline. It's a textual outline not being used for this course, so don't worry about this. But in New York State, the primary set of procedural rules is known as the CPLR, which is the New York Civil Practice Law and Rules. And there are different court rules that also might apply if we're in a particular court. So, for example, if we're in family court, the Family Court Act is our first default set of rules. And then if it doesn't cover whatever the issue might be, then we go to the CPLR. Finally, I note in federal court, if this is where our civil litigation is taking place, and again, I mentioned the Buffalo Creek disaster, which is a book that we use for another course and which we're not using for this course, so don't worry about that. But to the point, the main source of procedural rules in federal court is known as the Federal Rules of Civil Procedure. So that will end this screenshot video.